My name is Renee Parton, and I will be acting as your host for today's presentations. Before we get started, we have Secretary Dan Harris here to say a few words. Secretary Harris was appointed the Secretary of the Department of Safety and Professional Services in August 2022. Secretary Harris has spent his career in public service. He has previously served as the agency's Assistant Deputy Secretary in January 2019, and before that, he served as the Deputy District Director for Congresswoman Gwen Moore. Thank you for being with us today, Secretary Harris.
Thanks, Renee. I want to start by just giving a big thank you to specifically Renee Parton for the many, many hours of work that went into this event. Also want to thank the entire DPD team as well as the teams from across our agency who contributed to the presentations you'll receive today. And then lastly, but certainly not least, I'd like to thank all of you, all of our wonderful board members who have dedicated your time and your expertise to the professional management and regulation of your professions. I think we over the last several years have been engaged in efforts to empower you all to be the best board members, the most informed board members that you can be in your service to the state of Wisconsin. And this event is, I believe, our second annual event, so I think we're still certainly growing into it. And then recently, less than a month ago, we actually had our first board chair and vice chair meeting, which was an in-person meeting at the Wisconsin State Capitol. So all of these efforts and all of the many hours of work that have gone into this by staff is really meant to empower you all and to provide you with a foundation to serve the state of Wisconsin in the best way possible. We're proud of the collaborations that happen with each of you and each of our boards, and even more proud of the work product that comes out of the boardroom. So on behalf of the entire DSPS team, thank you once again for taking additional time out of your busy schedules to contribute to the safety and the economic development of the state of Wisconsin. With that, I'm happy to turn it back over to Renee.
Thank you, Secretary. We wanted to have our department leaders provide a brief overview of their areas and give introductions. As board members, you may occasionally interact directly with different parts of the department, but here today we have each division and office administrator or leader to discuss each of their areas that they oversee and how it may interact with the boards and councils and all the good work that we do. So with that, I'm going to turn it over to our Chief Legal Counsel, Al Romeyer.
Good morning, everybody. To echo the Secretary's comments, first of all, thank you for being here today. Thank you for volunteering your time, talent, and expertise to serve on a board, council, committee, or section. Again, my name is Al Romeyer. I'm the Chief Legal Counsel for the department, and I've served in that capacity since 2017. I've been with the department since 2013. Prior to joining the department, I served full-time in the military. And in 2018, I retired as a part-time Army National Guard service member with a little over 26 years of service, both here in the state and overseas. So again, welcome. So how does my job intersect with all of you? I'll give a few examples. First of all, I would note that 2 out of the 3 legal teams that you're going to work with as board, council, committee members fall under the Office of Chief Legal Counsel. Those teams are led by Deputy Chief Legal Counsel Sarah Norberg and Assistant Chief Legal Counsel Renee Parton. And both of them will be providing training to you later this morning. With regard to Sarah's team, she primarily handles legal reviews of credential applications. She will get into more details with regard to that later this morning. Renee's team consists of administrative rule coordinators and legal personnel who provide legal counsel and support to the various bodies that you all serve on. In addition to directly supervising Sarah and Renee, my position also intersects with all of you in a few other different capacities. Occasionally, matters may be delegated to me for review and to act upon by the boards or your bodies. Commonly, those are disciplinary matters or something of that sort. Also, should your body ever be involved in a lawsuit, I would be directly involved in leading those efforts and working with the Wisconsin Department of Justice to represent either the department's or the board's interests. A couple of examples with regard to lawsuits. The administration currently has a legal proceeding before the Wisconsin Supreme Court that challenges a legislative committee's authority to review, suspend, object to administrative rules that the boards and the department promulgates. So I'm obviously directly involved with that litigation. And another example would be when a credential holder or some other person sues one of your bodies. It could be a result of a denial of a credential, disciplining a credential, not disciplining a credential, promulgating a rule, or for some other reason. Basically, what it boils down to is if someone doesn't agree with a decision that your body has made and they seek review by the courts, then I would be involved with working with the boards and the Department of Justice. And then finally, I think one of the other primary areas where I would be involved would be if our agency receives a public records request on behalf of of anybody. It can be anybody. They don't even need to identify who they are. But should it involve board business or whatever, either myself or my team would work with the board members or committee members, section members, whatever it might be, to collect those records that would be responsive. And those could, conclude emails and text messages and other types of documents. So, and with that being said, I would just, I guess my word of advice for this morning, as you serve in these capacities as members of these bodies, it's really important to keep your board business separate from your personal business or your employment, those types of things. So one thing that I would just recommend is that you set up a separate email address, to receive those that board information. With that being said, I will just open it up for any questions if anybody has anything. Otherwise, I will turn it back over to Renee. And thank you very much.
Thanks, Al. Our next participant today is Pete McCombs. Take it away, Pete.
All right, thank you. So my name is Peter McCombs. I am the Division Administrator for the Division of Legal Services and Compliance, the enforcement arm of DSPS. I actually started my my career with the state working for DSPS. And after working in private practice for a decade, relocation from Milwaukee to Madison led to me taking a job as a prosecuting attorney. And after a few years, I moved on to the Department of Administration's Division of Hearings and Appeals. I worked as an administrative law judge for about 15 years there. In April of this year, I accepted an appointment to the division administrator position back at DSPS. And just to give you a little bit of an overview of what our division does within the department. So we provide legal services to professional boards and to the department regarding the investigation and discipline of licensed credential holders for violations of professional regulations and state statutes. We manage the life cycle of the case within our division. So we begin with the intake of complaints, investigation of the complaints allegations, pursuit of non-disciplinary and disciplinary outcomes where indicated, and afterwards monitoring compliance with disciplinary actions that are issued by the boards. The division is also responsible for management of a confidential program for impaired professionals, and we conduct business compliance inspections and financial audits. So DLSC works closely with board case advisors, the screening liaisons and other liaisons on a daily basis. Board members provide our attorneys, paralegals, investigators, our intake and monitoring staff with necessary and important profession-specific insights during our review and prosecution of non-compliance acts or omissions. So DLSC is arranged in 3 unofficial units. We have our intake unit. They administer the complaint intake and do the initial contacts with respondents. And they also oversee the screening process. And the screening process is DLSC's review of a complaint allegation and a response to determine whether or not to open a matter for further investigation. So they, for matters that are assigned to be open for investigation, an attorney, an investigator, and a paralegal will be assigned to that matter. So that makes up our enforcement unit. So our enforcement unit investigates, prosecutes, and enforces credential holder compliance with state laws and professional codes. And all of these members of our staff, so consumer protection investigators, paralegals, and attorneys, may work with the board-assigned case advisor. And that's a member of the board who consults on the case and the proposed resolution. Also, it's kind of important to note that our consumer protection investigators regularly inspect pharmacies, drug distributors and manufacturers, funeral establishments, and barber and cosmetology schools and establishments. Then, after a case has closed and discipline has been ordered, that issue then is referred to our monitoring unit. So monitoring staff will supervise credential holders' ongoing compliance with board orders. They also administer the confidential program for impaired professionals. It's referred to as PAP, or Professional Assistance Procedure. And the PAP program is a self-report, non-disciplinary confidential program available to any individual who has been issued a professional credential by the board or the licensing agency. The program's intent is to protect the public from credential holders who are impaired by reason of abuse of alcohol or other drugs by promoting early identification of chemically dependent professionals and encouraging rehabilitation. The PAP agreement lasts for 5 years. It includes AODA therapy, drug monitoring, and Alcoholics Anonymous or Narcotics Anonymous meetings as part of the agreement. So as members of your respective boards, you will likely become very familiar with many of our DLSC staff members. We appreciate and rely upon the service that you provide, including your subject matter expertise. We appreciate your attendance and participation today, and I will have more to say on the whole topic of my division later in today's presentation. So I will take questions at that time after that presentation has concluded. So thank you very much.
Thanks, Pete. Next up, we have Sarah Berry.
Well, good morning, everybody. I am here to give an overview of the Division of Policy Development. I'm the Division Administrator. Our division manages all the professional credentialing boards, advisory, and trades councils housed at DSPS. This involves facilitating board meetings, serving as a liaison between the boards and the department, and managing the administrative rule promulgation process for self-regulated professions. We currently have over 70 active boards and councils under our purview. With guidance from the Controlled Substance Board, we oversee the state's prescription drug monitoring program, which is a valuable tool to help combat the ongoing prescription drug abuse epidemic in Wisconsin. We also contain the Office of Education and Examination, which administers trades exams, approval of professional education programs, jurisprudence exams, continuing education approval, and exams for a few other professions. So far this year, we have administered 3,300 trades exams. We've processed 633 continuing education courses, administered 5,600 business and health exams, and conducted 170 licensee continuing education audits. Our division also contains the Educational Approval Program, which evaluates and approves most private, for-profit, technical, career, distance learning, and degree granting schools. The program works to ensure Wisconsin consumers that EAP-approved schools are well-run, educationally sound, and financially stable. We work closely with the Division of Industry Services on our trades code update projects, of which we have several going on right now. We also closely collaborate with the Division of Credential Processing on the approval of new licenses, license renewals, and education program approval. I'm sure I'm not covering everything that our division does, but that's a brief overview, and I look forward to participating in the rest of the meeting today, and so glad you're here to enjoy the training.
Thank you, Sarah. Next, we'll hear from Audra Cohen-Plata.
Good morning, everyone. Thanks for having me. My name is Audra Cohen-Plata, and I am currently serving as the Division Administrator for the Division of Performance Management. I am relatively new to DSPS. I started in this role in July this year. And just a little about me, I come to this role having worked nearly 12 years for a member in the US House. I previously served as a union steward and am a past president of the nonprofit Wisconsin Women in Government. And just to give a brief overview of performance management, or DPM, I will share DPM is relatively small. We have about 14 personnel currently, and we are the division that handles administrative functions for the agency. We provide support to all of the other divisions and our external stakeholders as well. Some of the business activities that are housed in DPM include support for IT, hardware, and project management. We assist with records and forms management. We are currently embarking on an effort to employ low-code fillable forms that offer greater accessibility than PDFs. My division also handles fleet and parking services for our staff and visitors. We are the tenant services liaison for both our Waukesha and Madison offices. And our staff also handle budget management, procurement, and our financial program. And I'll just share some interesting tidbits, but with our procurement efforts, we procure truly a wide range of goods and services and things that range from our standard paper and pens and pencils to assisting with translation services for investigations in a host of foreign languages. And interestingly enough, golf cart rentals. There's a state contract for that, so that when inspectors are in the field at the state fair, for example, they can get around and conduct their business. And I will just close by touching on, what relation does DPM have to you all and professional boards generally? And I will say that DPM is the entity that is typically working in the background to support board services staff here in the agency, and then by extension, you all. And that support is typically carried out as a larger touch point with our financial staff. So our finance program staff are the ones that will process the expense reimbursements that get submitted from board services staff. And we provide a lot of support and advocacy with our budget team. We recently submitted our biennial budget request, and we really highlighted some priority positions there, such as health professions administrative rules officer, pharmacy practices consultant, and a host of paralegal and attorney positions that carry out all of the investigative and legal work that you all assist with. So I will stop there. I appreciate being invited to join this presentation today. Thank you so much.
Thank you, Audra. Next up, we'll hear from Brandon Piper. Brandon?
Thank you, Renee. Good morning, everyone. My name is Brandon Piper. I'm the administrator of the Division of Industry Services. I'm going to take a couple of minutes just to introduce you to what we do and where you can find us. I apologize. I'll have to make this kind of brief. My voice is beginning to fail me. I'm sure it's going around to help more folks on the call. DIS is comprised of 105 staff members and is responsible for regulating 25 program areas. Our regulation generally consists of plan review, inspection, auditing, complaint investigation, consultation, and we serve as subject matter experts, as Sarah mentioned, on our various code councils. We do this kind of in an effort to ensure consistency and in compliance across the state with our administrative code. If you're looking for us, we're easy to find. This is our department website, dsps.wi.gov. Once you're here, you can click on the A to Z program list. Rather than go through these one by one in our limited amount of time, I will kind of just point you to where you can view all of this. Every program area on here, minus the prescription drug monitoring program and the unarmed combat sports, falls under the DIS umbrella. So if you need to reach out to any of our staff at any given time, just go here, click on your program area, and the site has various reference material, guides, frequently asked questions, but also even has contact information directly for our staff, depending on your geographic area. So anytime you need to get a hold of us, we're readily available. Feel free to reach out and we will help you with anything that we can. So back to Renee.
Thanks, Brandon. And finally, we have Nico Rude. Nico?
Morning, everybody. As Renee mentioned, I'm Nico Rude. I'm the Division Administrator for the Division of Professional Credential Processing. Prior to this role, I've been in this role for about 2 years now. Prior to that, I ran the Office of Comprehensive Health and Wellness at the Wisconsin Department of Military Affairs, and before that served on active duty in the U.S. Air Force. As Division Administrator for the Division of Professional Credential Processing, my team is responsible for application review and eligibility determination for about 50,000 initial credential applications every year, as well as reviewing and determining eligibility for renewals of about 200,000 applications each year. In addition to these responsibilities, the division is also in charge of the agency's customer service center, and we manage the unarmed combat sports program. A quick overview of the organization of DPCP. We do have 2 health credentialing teams. The first, and we do manage, I should mention, work with boards for about 240 different credential types in the Division of Professional Credential Processing. So I'll give a very quick overview of our organization, but of course won't be able to mention every single profession that we do work with the boards on. We do have 2 health credentialing teams. The first health credentialing team supports the medical board and the affiliated credentialing boards. Health Team 1 also manages the nursing board and works on applications for RNs, APNPs, and others. Health Team 2 manages professions in the mental and behavioral health fields, as well as dentists, dental hygienists, pharmacy, and chiropractic professions. The division's Business, Trades, and Manufactured Homes team reviews applications for things like realtors, funeral home directors, appraisers, among many others. They also administer our building trades credentials, review applications for building trades credentials, and they do manufactured homes credentialing as well as titling. The final team that we have manages the department's customer service center and the renewals team. So they interact with everybody that is contacting the agency. We do receive hundreds of thousands of customer contacts through emails, support tickets, phone calls, and other means every year, and a small team manages that activity. That team also manages all of our renewal applications. So again, a small team that has an outsized impact on credentialing, reviewing all of our renewal applications. We work, of course, with boards by determining eligibility based on requirements set forth by the board and by law and statute. I will say we have a very good relationship with our credentialing boards through the liaisons. I know we're going to talk about some of that today. But certainly at any time, if you do need assistance with anything that you're doing or have any questions about the credentialing process, you can reach out to me. Or as I mentioned, we do have our 4 teams as well, and the supervisors on those teams are always very responsive and happy to assist with any questions you might have about our processes, and certainly happy to answer any questions you might have. I think we have some time here to talk about that as well. So thank you for the time this morning. Thank you for your service to the community and state. And with that, I'll turn it over to Renee.
Thanks again, everyone, for providing our department overview today. We'll just continue on to the prepared presentations for today. Those presentations are on board authority. We have these presentations pre-recorded, so you might hear some duplicate information from our earlier presentations or later on today. I think we're ready to go.
Welcome and thanks for attending our training today. My name is Renee Parton and I am the Assistant Deputy Chief Legal Counsel for the Department of Safety and Professional Services. I have been with the department close to 10 years working in various attorney roles. In my current capacity, I supervise our board counsels and administrative rule coordinators, and I oversee legal issues related to our boards and the Division of Policy Development. Today, our overall topic is board authority. You will hear about different powers the boards have in making decisions, each different type of board or council, and its unique process of rulemaking. If you have any questions during this presentation, you can either type them into the Q&A feature in Zoom or hold them until the end, where we will be fielding questions. The board's authority. Overview in the board's role within state government, rulemaking, power, and limits. Just so you know, I will be discussing all different types of boards constructions within and attached to the Department of Safety and Professional Services, but we'll go into more detail about examining boards and their unique powers. The professional boards attached to DSPS are part of the executive branch. And as a part of the executive branch, professional boards attached to DSPS carry out the program and policies as determined by the legislature. The legislative branch's objective is to set those policies and programs and to review its performance. Our judicial branch will adjudicate any conflicts which may arise. It is the traditional concept of American government that there be three branches and that they are functionally separate without intermingling of authority except as specified by law. As you can see from this beautiful flowchart, examining boards, affiliated boards, and non-examining boards are established by the legislature to be under the Department of Safety and Professional Services, but also an independent entity of the executive branch with its own powers. The department provides administrative duties for each of these boards, so they may be a part-time entity. This allows for consistency and the building of institutional knowledge, but also allows the board the ability to delegate tasks to the department to keep everything running smoothly. Here is a breakdown of the different board categories under DSPS, as created by the legislature in Wisconsin Statutes Chapter 15. Examining boards are defined as such under Chapter 15 and are our largest groups of boards. All of the affiliated credentialing boards attached to DSPS are affiliated with the Medical Examining Board. The non-examining boards have individually delineated authorities by statute and share duties with DSPS. The auctioneer, cemetery, and real estate appraiser boards mostly function like examining boards, but they lack the ability to promulgate their own rules and rely on the department to perform that function. Wisconsin Statute 15.03, attached for limited purposes. Any council or board attached under this section to a department shall be a distinct unit of that department. Any council or board so attached shall exercise its powers, duties, and functions prescribed by law, including rulemaking, licensing, and regulation, and operational planning within the area of program responsibility of the council or board, independently of the head of the department or independent agency. But budgeting, program coordination, and related management functions shall be performed under the direction and supervision of the head of the department. To break it down, attached for limited purposes means that there is an individual distinct unit of DSPS. The boards will conduct their own business of rulemaking and licensing, and DSPS shall handle the budgeting, program coordination, and other management functions. I will now go into more detail about the powers granted to examining boards. As noted, even for examining boards, the department provides many administrative functions to allow for smoother operations. Pursuant to Wisconsin Statute 15.08 sub 5, examining board means a part-time body which sets standards for professional competence and conduct for the profession under its supervision, prepares, conducts, and grades the examination of prospective new practitioners, grants licenses, investigates complaints of alleged unprofessional conduct, and performs other functions assigned to it by law. These 5 powers form the most understood purpose of occupational licensing boards. Additionally, each board may compel the attendance of witnesses, administer oaths, take testimony, and receive proof concerning all matters within its jurisdiction, shall promulgate rules for its own guidance and for the guidance of the trade or profession to which it pertains, and define and enforce professional conduct and unethical practices, not inconsistent with the law related to the particular trade or profession. May limit, suspend, or revoke or reprimand the holder of any license, permit, or certificate granted by the examining board. These authorized powers can be found in Wisconsin Statute 15.08 sub 5. Under overall duties, board shall improve the profession. This mission may look different to each board and change over time, but specifically calls for boards to set educational standards or trainings needed for the profession. Boards should also try and provide clarity about the profession or trade and how it relates to the general welfare of Wisconsin. These duties are specifically listed in Wisconsin Statute 15.08 sub 6. The affiliated credentialing boards have a very similar duty delineated in 15.085 sub 6. These established objectives are more broad principles, similar to the concept of Justice Hagendor's recent dissent in Wisconsin Legislature versus Palm. As government grew, the legislature began to enact statutes that looked more like broad, undefined goals rather than concrete laws. Doing so left specific policy decisions to the executive branch, of which you as board members are a part of. Here we show how affiliated credentialing boards relate to the executive branch. As the head of the executive branch, we have the governor who will appoint members of the medical examining board. We have the DSPS agency, which the governor also appoints the heads of the DSPS agency. The medical examining board has oversight over the affiliated credentialing boards that are attached to DSPS. All of our medical affiliated credentialing boards are responsible to regulate a profession that does not practice independently of the profession of the medical examining board or physicians under that board. Or they may practice in collaboration with the medical examining board. With the advice of the medical examining board to which it's attached, sets standards of professional competence and conduct for the profession under the affiliated credentialing board supervision, reviews the qualifications of prospective new practitioners, grants credentials, takes disciplinary action against credential holders, and performs other functions assigned to it by law. This is a very wordy way to say that they work in concert with the medical examining board, as the medical examining board's physicians generally have either oversight over or work in collaboration with those professions that are affiliated. Similar to examining board powers under Wisconsin Statute 15.085 sub 5, specific delineated powers are granted to the affiliated credentialing boards. These powers include may compel the attendance of witnesses, administer oaths, take testimony, and receive proof concerning all matters under its jurisdiction, may limit, suspend, or revoke, or reprimand a holder of any license, permit, or certificate granted by the affiliated credentialing board. The major difference comes under sub 3. They shall promulgate rules for its own guidance and the guidance of the trade or profession for which it pertains, and define and enforce professional conduct and unethical practices not inconsistent with the law related to the particular trade or profession. But in addition to the procedures established for examining boards, they must also present the rules to the medical examining board for their review and comment, and work with the medical examining board if issues may arise. The period of review allows for feedback, and they may hold additional public hearings if necessary before finalizing the rule. Other types of bodies attached to DSPS are known as advisory committees and affiliated councils under Chapter 15. These committees are appointed by the DSPS secretary and perform very specific advisory purposes. The membership on these committees are also appointed by the DSPS secretary, and unlike the examining boards and the bodies that we've previously talked about to this point, they don't have a governor appointment associated with them. And so they don't go under Senate confirmation. Here's a list of these councils that the department has formed under Chapter 440 and under Chapter 15. The medical affiliated councils serve the medical examining board in an advisory capacity in the regulation of specific professions, all specifically established under Chapter 15. The other affiliated councils established under 15 are formed to advise the department on numerous functions, such as building codes and specific credentials. They help provide a subject matter expertise when needed. Advisory committees under Chapter 440 are formed to advise the Secretary and make recommendations for solutions and policy alternatives of problems that may arise in specific functional areas of the state government. As you can see here, there's a long list and a varied list of committees that have been formed to help advise the Secretary and give very specific subject matter expertise. DSPS advisory committees and councils under Chapter 440 and 15 are authorized the department to appoint these committees to advise on matters related to regulations of credential holders as the operation of the department requires. Some important reminders to take into consideration: that some of these advisory committees and councils have very specific delineated powers and membership that are established by law. The primary function is typically to advise the department on rulemaking projects. The councils look to advise the department on recommendations for other solutions and policy alternatives, but it's generally in the form of a rulemaking project. Councils formed under Chapter 15 shall elect a chairperson and the other officers at the first meeting of every year, just like the examining boards and other boards as we've previously discussed. Besides the specifically authorized councils and committees, DSPS, as mentioned, has the authority to appoint a committee under 440.042 for advisory purposes. One example of this would be the Interdisciplinary Advisory Council. This council is formed of liaisons from other professional boards to discuss mutual matters of concerns, using the subject matter expertise to help the department and the professionals evaluate matters of public safety. Authorized power for our boards is rulemaking. Rulemaking generally, as set by statutes, laws promulgated by a legislature. Any change to the statute requires a legislative action, Boards do not have the authority to change that statute, and the statutes and legislature give the boards the authority to write the rules. One caveat to this is that the Controlled Substances Board can directly change the statute when scheduling drugs, but this is authorized by law and is the only exception. Rules that are written in the administrative code are written based on subject matter expertise of the agency or the administrative bodies, such as examining boards. The purpose is to add more specifics to the law, and to do that by making a rule to further explain. This allows for the boards to clarify the statutes and enact legislation through its rules. Explicit rulemaking authority is a phrase often heard when discussing a new legislative act creating a need to draft a rule for each board. Our first goal is to look at what explicit authority was granted by that act from the legislature to make the rule, and then what is necessary to accomplish the intent of the act. The Martinez case established that agencies have no inherent constitutional authority to make rules, but explicit authority was further defined and reviewed under the Clean Wisconsin case to mean a clear, open, direct, or exact, which went on to say that agencies may rely upon grant of authority that is explicit, but also broad, when undertaking any agency action. Consider the board's grants of power we have already gone through in terms of granting licenses and reviewing matters of misconduct when we are going over explicit rulemaking authority. To summarize, agencies have explicit rulemaking authority, as we've previously reviewed, but you can find that each agency or individual examining board's authority in your specific chapters in the Wisconsin statutes. The legislature has expressly granted this authority, and it's not something that we are implying. When starting a rule project, we need to establish such explicit authority to create the rule within our scope statements. And please note, the Martinez case listed here is currently under the Supreme Court review. In Evers v. Markland case, the Wisconsin Supreme Court has granted the complainant Evers leave to petition the court for original action on the issue of whether the veto, which is a suspension or objection provisions under Wisconsin Statute Chapter 227, violate the separation of powers. To give some more details, this includes the action taken by the Joint Committee for Review of Administrative Rules, also known as JCRER's, action related to the rules promulgated by our Marriage and Family Therapist, Professional Counseling and Social Work Social Work Examining Boards, as well as it relates to unprofessional conduct in the Wisconsin Administrative Code, Chapter MPSW 20, and department rules as it relates to updating the Commercial Building Code, as recommended by the Commercial Building Code Council. The petition states that the courts have broadly recognized that blocking executive branch agencies' rules violates bicameralism and presentment procedures and infringes on the executive and judicial authorities. This case will examine whether the JCRER veto provisions to block executive branch agency rulemaking violates the separation of powers. I know that was a lot, but if you have any questions about this current case, you can reach out to me and I'll provide my email at the end of this presentation. There's also a lot on this slide to take in. Essentially, rulemaking is a large part of what our board's duties are, and its powers derive from Wisconsin Statute Chapter 227. And then there are professional specific legislation that discuss individualized enactments to allow for rulemaking. We have discussed a lot of powers today, but here are some of the limits. Rules cannot exceed the bounds of the correct interpretation of the statute. Sorry. And also under 227, each agency may prescribe forms and procedures in connections with the statutes to help enforce the laws to administer it. Each examining board must make rules for its own guidance and for the guidance of the professions, rules that define and enforce the professional conduct and unethical practices. Here are some more of the limits of rulemaking. Rules cannot conflict with state laws, the statutes. No rule, either by its terms or by its application, may discriminate for and against any person by reason of sex, race, creed, color, sexual orientation, national origin, or ancestry. And each person affected by a rule is entitled to the same benefits and is subject to the same obligations as any other person under the same or similar circumstances. Bringing home this point, in the 2019 case Koschke versus Taylor, the Wisconsin Supreme Court stated, when an administrative agency promulgates rules, they are exercising legislative power that the legislature has chosen to delegate to them by statute. Stated otherwise, agencies have no inherent constitutional authority to make rules, and their rulemaking powers can be repealed by the legislature. It follows that the legislature may place limitations and conditions on the agency's exercise of rulemaking authority, including establishing the procedures by which the agency may promulgate rules. Again, this is something that may be changing in the upcoming term, but this is addressing the limits we have upon our rulemaking authority. As I've alluded to, the courts have a lot to say about rulemaking. The power of the executive rulemaking has been subject to a lot of recent cases in Wisconsin and federally. This slide provides some further clarification from the courts on the executive power and its limits. I know our meetings usually focus on the mechanics of rulemaking, such as the chart that shows every single step of the 30-month process. But before that process even starts, we really need to consider what our granting authority is to make those each specific rule. I'm not going to read all these quotes, but I have them here for your reference materials. I hope this presentation laid a firm foundation for how our administrative bodies interact with each other and with the Wisconsin government as a whole. We discussed the breakdown of our different boards and councils, as well as where the power to make rules comes from and what the limits might be. If you have any questions on this topic, please reach out to your assigned rule coordinator, legal counsel, or myself. I've put my email on this slide if anyone would like to discuss these topics or others as they relate to the board's authority, if they come up later.
Thanks, everyone. Now we have a few questions from that presentation. The first question comes from Ramona. She is on our massage therapy and bodywork therapy board. She asks, who oversees the online exams for new applicants and takes part in their licensing as part of their licensing requirements? So the online exams for many of our professions, almost all the business and some of our health professions are actually administered directly in-house through our Office of Exams and Education, or Education and Exams. The division administrator, Sarah Berry, talked about this office earlier in our presentation today. And they have a system, it's called PAR test, where these exams are administered. But the department contracts with other entities to administer exams for other credentials, such as our trades exams and our real estate are from Pearson VUE, and they offer options for sites and ways to take their online exams. And then we also do non-online exams that are done in-house with the department. Bill Neitzel asked, has there been a decision to clear up the confusion regarding the allowable material and exam application an exam applicant may take into a DSPS administered trades exam versus a Pearson VUE exam site? Is there a list available online? Thank you for that question. I don't believe we have a list available online as of yet. I see that Sarah Berry is typing an answer to that question as we speak, but actually it's gone. Hold on one sec. Oh, our website has already been updated, it looks like. So we can provide that content to you directly, Bill, after this presentation. Thank you for your question. Okay, I think that's all the questions we have so far. Oh, let me go back. Nope, there's another question came in on real estate licensing exams. Has DSPS ever published an occupational specific technical support on outcomes of these exams administered by DSPS? Oh, for licensing exams, not real estate, sorry. Thank you, Linda. She's from our dentistry examining board. We have not, as I'm aware of, published any sort of outcomes from these exams. We do provide, obviously, the applicant their outcomes, but if you're looking for a occupation specific report, I know that we have reports for some boards on national exams like the NCLEX and for how our schools are doing, but that is a function of the reporting requirements in our review of nursing schools under the Board of Nursing's authority. For dentistry, I know that we've been looking a lot at the dentistry pre-requirements, so this might be something you would want to talk with board counsel and your executive director about further, if there's a way that we can provide a report to the board. Thank you very much for all of your questions. Okay, I'll give one more minute for any questions to come through, as I believe we're running a little ahead of schedule. I believe there is a hand raised. If Brenda, if you want, since we have a moment, you can turn it over to the participant.
I've sent a note requesting unmute, so we'll see if they're still available.
Okay. If not, you can put your question in the chat. Oh, is it Amy Hefferman? Hi, Amy. Would you like to ask your question?
She is unmuted on our end. I'm not hearing you, Amy. You want to check your microphone. I think we are running into some technical difficulties. Amy, if you could please just put your question in the Q&A panel. We'll make sure that we come back to it.
Okay, we got another question. And it looks like it was a mistake. Thanks, Amy. Okay, so we got another question from Tanya Letman-Shu. Are the liaisons between the boards and committees and the legislature, as the legislature has been advancing their objectives, it has caused some problems historically. I am on a DSPS advisory board specifically regarding substance use and mental health services. So yes, in a couple of ways, we have a staff member with DSPS who serves as our liaison with the legislature. So he's a full-time staff, and that's part of his role. But individually, we have our examining boards and our affiliated the board functions often appoint a liaison to be the legislative liaison for those boards. And if there was a need, they may be called to speak on behalf of the board with the legislature. Generally, if there's an issue of legislative concern, those matters would come before the full board and they would discuss it before any sort of liaison would need to speak on behalf of the board. We often would see that the boards may review legislation and so that they can understand what's going on. Sometimes when a bill is being proposed, the legislature will proactively reach out to us or the boards to get our opinions on the language and the effect of what the bill will have. So there's many ways which the department and our boards will interact with the legislature. The DSPS Advisory Board on Substance Abuse Credentials is an advisory board capacity that we have convened to work on our substance abuse rules and do a comprehensive overview. There has been a lot of legislation in the last few years that cause our rules to need to be updated. But because those are SBS rules or the department rules, the committee serves an advisory capacity from the secretary. So that would be relying on our staff to advise and to work with the legislature in that capacity. But also the council itself does have we look to them for their subject matter expertise, and that's one of the main reasons why we have advisory councils, is because we understand that they have the subject matter, and we really look for those opinions when we are undergoing and interpreting the legislation that comes through. So thank you very much for your question, Tanya. Okay. Well, thank you all for that ends my presentation for today, but you'll still see me as we continue on this road. I would like to next introduce Sarah Norberg and thank her for being our one that has to do a presentation 2 years in a row. So thank you again for agreeing to present this year, Sarah. Sarah joined the Department of Safety and Professional Services in 2010 and currently serves as Deputy Chief Legal Counsel and an Attorney Supervisor for the Credentialing legal team. Prior to working for the state of Wisconsin, Attorney Norberg worked as in-house litigation counsel for a large insurer and litigated intellectual property infringement cases. Thanks, Sarah. And again, this is pre-recorded, so there might be some repetitiveness, but Sarah's here and she'll answer questions at the end. Thanks.
Good morning. My name is Sarah Norberg. I am currently the DSPS Deputy Chief Legal Counsel and Attorney Supervisor for the Credentialing legal team. Although for those of you who have been around for some time, you may know me from other roles I've held at the department over my nearly 15-year tenure here. In any event, today I'm here to talk to you about the board's credentialing authority. During today's presentation, I intend to cover where the board's credentialing authority comes from and what the board's credentialing authority includes. Additionally, my presentation will conclude with a discussion of the board's credentialing authority related to arrest and conviction records. The board's credentialing authority comes from the legislature and is codified in the Wisconsin statutes. In Wisconsin Statutes Chapter 15, the legislature created the Department of Safety and Professional Services and the various different boards attached to it. Some of you might be members of an examining board. An examining board is a part-time body which sets standards of professional competence and conduct for the profession under its supervision. It prepares, conducts, and grades the examinations of prospective new practitioners, grants licenses, investigates complaints of alleged unprofessional conduct, and performs other functions assigned to it by law. Examining board includes the Board of Nursing. Some of you might be members of an affiliated credentialing board. An affiliated credentialing board is a part-time body that is attached to an examining board to regulate a profession that does not practice independently of the profession regulated by the examining board, or that practices in collaboration with the profession regulated by the examining board. And with the advice of the examining board to which it is attached, sets standards of professional competence and conduct for the profession under the affiliated credentialing board supervision, reviews the qualifications of prospective new practitioners, grants credentials, takes disciplinary action against credential holders, and performs other functions assigned to it by law. Some of you might be members of non-examining or non-affiliated credentialing boards. Boards like the Auctioneer Board and Real Estate Appraisers Board assist with professional regulation, but do not have direct credentialing authority, which is handled by DSPS. Profession-specific authority is given to each board in its own statutory chapter, located between chapters 441 and 480 of the Wisconsin statutes. Examining and affiliated boards have licensing authority. That means they have the authority to grant credentials if certain requirements are met. Generally, these requirements include submission of an application, payment of a fee, completion of specified education, passage of an examination, and the applicant must not have an arrest or conviction record subject to the requirements of the Wisconsin Fair Employment Act. Boards appoint members to be credentialing liaisons to assist DSPS staff with determining whether applicants meet licensing requirements. Examining and affiliated boards also have the authority to deny a credential if an applicant fails to meet the aforementioned requirements for licensure, has engaged in fraud or misrepresentation in the application process, is unfit, incompetent, or impaired, or has engaged in unprofessional conduct, such as having out-of-state discipline against a similar credential, engaging in unlicensed practice, providing substandard care, committing boundary, record-keeping, billing, or advertising violations, or obtaining compensation by fraud. Additionally, all boards and DSPS have the authority to deny a credential if an applicant is delinquent in making child support payments. If there is authority to deny a credential, but the board believes conditions or requirements can be placed on the credential that would allow the individual to practice in a manner that adequately protects the public, the board may issue a limited license. Limitations can be crafted on a case-by-case basis to address the specific concerns raised by an applicant in their application. Examples include drug and alcohol monitoring, treatment, supervision, and work reports. Boards also have the authority to ask for more information, including fitness to practice evaluations, alcohol or other drug abuse assessments, or evidence of rehabilitation. DSPS's mission is to promote economic growth and stability while protecting the citizens of Wisconsin. The objective of professional licensing is to allow professionals to work, but only in a manner that protects the health, safety, and welfare of the public. As previously noted, boards can deny an application if an applicant has pending charges or convictions subject to the requirements of the Wisconsin Fair Employment Act. On initial applications, applicants are asked whether they have pending charges or convictions. On renewal applications, applicants are asked whether they have pending charges or convictions since their last renewal or initial licensure if this is their first renewal. If they answer yes, we run a criminal background check. There are also some professions which require fingerprinting. For those professions, we run a criminal background check regardless of an applicant's answer to the charges and convictions question. If you serve as a credentialing liaison and receive a file from staff asking for assistance with a CIB review, please note CIB stands for the Wisconsin Department of Justice's Crime Information Bureau, from whom we obtain the criminal background checks, and is how we refer to criminal record reviews. Certain boards also have statutory prohibitions on licensure for felons. The Real Estate Examining Board prohibits initial licensure for felons subject to certain requirements. And the Cosmetology Examining Board prohibits licensure for individuals who have been convicted of a felony committed while engaged in the practice of cosmetology. The Wisconsin Fair Employment Act is codified in Chapter 111 of the Wisconsin Statutes. The Act provides that no licensing agency may engage in any act of employment discrimination against any individual on the basis of arrest or conviction record. However, the Fair Employment Act also provides exceptions. It is not employment discrimination to refuse to license or suspend from licensing any individual who has a pending criminal charge if the circumstances of the charge substantially relate to the circumstances of the particular job or licensed activity, and the charge is for an exempt offense or a violent crime against a child. An exempt offense is generally a crime against life and bodily security, such as homicide, battery, sexual assault, or child sex crimes. Another exception to employment discrimination in licensing is for the denial of applicants who have criminal convictions if the circumstances of the crime substantially relate to the circumstances of the particular job or licensed activity. Did you notice some overlap between the two exceptions? Both exceptions require a substantial relationship between the circumstances of the charge or conviction and the circumstances of the job or licensed activity. So, what does substantial relationship mean? The courts have determined that a substantial relationship occurs where the tendencies and inclinations to behave a certain way in a particular context are likely to reappear later in a related context based on the traits revealed. The crux of the inquiry is the circumstances which foster criminal activity. For example, the opportunity for criminal behavior, the reaction to responsibility, or the character traits of the person. Here are some examples of convictions, the circumstances of which may be substantially related to the circumstances of a particular job or licensed activity. First, for a certified public accountant applicant, a conviction for tax evasion or fraud may be substantially related to the practice of accounting and a permissible reason for denial. For a registered nurse applicant, a conviction for forging prescriptions, illegal drug possession, child abuse, or multiple operating while intoxicated convictions that reveal alcohol or other drug abuse issues may be substantially related to the practice of nursing and a permissible reason for denial. For a real estate salesperson applicant, a conviction for criminal damage to property, breaking and entering, burglary, theft of personal property, or fraud may be substantially related to the practice of real estate, and again, a permissible reason for denial. Finally, for a pharmacist applicant, a conviction for illegal possession of narcotic drugs may be substantially related to the practice and a permissible reason for denial. If we have an applicant whose conviction record is deemed to be substantially related to the practice of the profession they seek to enter, and the board wants to deny the credential, the board must first state in writing how the circumstances of the offense relate to the licensed activity, and second, allow the applicant to show evidence of rehabilitation and fitness to engage in the licensed activity. This can be accomplished by a notice of intent to deny that DSPS staff will assist the boards in drafting. Please note, however, these requirements do not apply if the conviction is for an exempt offense. Again, an exempt offense is generally a crime against life and bodily security. Competent evidence of sufficient rehabilitation and fitness to perform the licensed activity may be established by an honorable discharge from the military, successful completion of probation, elapsed time with no new criminal activity. This would be for a period of at least 1 year, education, employment, and letters of reference. This evidence must establish sufficient rehabilitation subsequent to the conviction. Boards may also consider the applicant's age at the time of the offense, the circumstances of the offense and any mitigating factors, and the nature and seriousness of the crime. Once it has been determined that the conviction is substantially related to the profession and rehabilitation has not been established, the board may deny the application, offer a limited license with conditions and/or requirements that will permit professional practice while also protecting the public, or ask for more information from the applicant, such as a fitness to practice evaluation, an alcohol or other drug abuse assessment, or other evidence of rehabilitation. A credentialing attorney or board counsel will assist the boards with all of these options. One final note about the Fair Employment Act as it relates to professional licensing. The Fair Employment Act sets forth a mechanism for applicants to apply for a predetermination as to whether the applicant would be disqualified from obtaining a license solely because of their conviction record. If an applicant is determined to be disqualified from licensure because of their conviction record, they are spared the time and expense of pursuing the licensing requirements for a license they will not be given. Such applications must be handled in an expedited manner. For this reason, most boards have delegated authority to make decisions on predetermination applications to the credentialing attorneys. A predetermination decision that an applicant is not disqualified based on their conviction record does not preclude the boards from denying a future application for other reasons, such as test failure, civil lawsuits, prior discipline, incompetency, or inadequate education. I've included a flowchart of the board's authority to deny licensure to those with arrest and conviction records for your reference. Thank you so much for your time and attention today, as well as your service to the professionals and citizens of the state of Wisconsin. You serve a very important role in the credentialing process.
Thank you, Sarah, for your presentation. We have one question already in our question and answer. Would you like me to read it?
That would be great.
Okay, yeah. Our question comes from Gregory Schmaling, sorry, Dr. Schmaling, from the Medical Examining Board. When does personal misbehavior and professional misconduct? How should boards address this? Physical violence may or may not be substantially related to the practice of medicine. How would this be addressed? And then he gave a link about it's a link to an article from the Justice Department about an anesthesiologist who was convicted of tampering with IV bags, but that was linked to cardiac emergencies. I can provide you the link, but if you want to address the question generally, we could address the question more specifically offline.
Sure. I think the answer goes back to the case law that was cited, and ultimately it comes down to the traits of the individual and whether the professional activity that they may get licensed to engage in are going to present the opportunity for them to engage in similar conduct. So I'm happy to review the article after this presentation and get back to you, Dr. Schmaling. But I really do think it comes down to whether the traits of that were exhibited in the offense itself by the individual might reappear later in a related context.
From Bill Neitzel of our Electrical Code Counsel, he asks, we received questions in the trades professions of why they have to fill out their conviction history.
And that would be based on the law and for the trades professionals in the Wisconsin Administrative Code, Chapter SPS 305. It talks about the licensing or credentialing of individuals, and they must not have an arrest or conviction record. Specifically, SPS 305 talks about misdemeanors and felonies. So that is why they're asked the question. We've built that into our new licensing system as a declaration for the trades professionals. So they need to answer that question. And if they answer in the affirmative, we're running the background checks, collecting pertinent documents, and conducting those reviews.
I know we get a lot of these questions during our board meetings as we review convictions and other credentialing determinations, as convictions is not the only credentialing consideration that we make.
Sure, and for those of you who served on boards and attended last year's presentation, we talked about the role and the responsibilities of the credentialing liaisons and the work that we do together with regard to other reviews beyond convictions in terms of malpractice or reciprocity applications from other states, out of state or foreign discipline. My team works on all of those issues, works very closely with all of the board's credentialing liaisons. So we have a lot of work, and we appreciate all of your subject matter expertise reviewing all of these applications.
We have a question from Stephanie Williams. How are convictions reported, such as an OWI? Is it reported before renewal?
That's a great question. Multiple ways. So one is the question is asked on the initial applications for all professions. So before someone ever gets a license, they are asked whether they have pending charges or convictions. The question is also asked at renewal. It is asked of everyone, but it's a more limited time. We're not going to go back to the beginning again. So we basically ask them whether they have any charges, pending charges or convictions since their last renewal, or if it is their first renewal since initial licensure. I don't want to step on Pete's toes, but there are also requirements for licensees to report convictions within 48 hours of being convicted to the department. So there is an ongoing requirement to report. And the department has a very specific form for that reporting that can be found on the DSPS website. Those reports go to Pete's division, the Division of Legal Services and Compliance, for review and investigation and potential discipline against the licensee at that point.
Thank you, Stephanie. She is on our geologist section. For reporting an OWI in Wisconsin, your first OWI is an actual ordinance violation. So how does that come into play?
Thanks for bringing that nuance of the question up that I forgot about. So some professions, most professions require reporting of a crime, and a crime would be a misdemeanor or a felony. Those are what need to be reported within 48 hours. Other professions have expanded statutes and regulations that require the reporting of any violation of law, which might include an ordinance violation, like an OWI first in Wisconsin. So those specific professions also must report an OWI. Off the top of my head, those are the private security professions that are directly regulated by the department. The Board of Nursing applicants and licensees would need to report that. Midwives and some of the pharmacy professions have laws that talk about other violations of law that equate to ordinance violations, like OWI 1s, some disorderly conducts, things of that nature. But generally speaking, if the requirement is reporting of a crime, which is a misdemeanor or felony, that does not encompass basic OWI 1 in Wisconsin. However, OWI 1s out of state are misdemeanors in many of other states, and so those would need to be reported as a crime.
At this point, I'm going to thank Sarah for her presentation and all of her knowledge that she brings. And then we're going to move on to our next presentation. So thanks, Sarah.
Thanks, Renee.
Yeah. Our next presentation comes from Pete McCombs. Pete already gave his introduction earlier, as he is the division administrator for our Division of Legal Services and Compliance. So I will just again express my gratitude for him for being here today and creating the next presentation on disciplinary authority. So with that, it's pre-recorded, but Pete is here and he will answer questions live after the presentation.
Good morning. Again, my name is Peter McCombs. I'm the Division Administrator with the Division of Legal Services and Compliance. Today we are here to discuss the bases of board disciplinary authority from the perspective of the compliance enforcement arm of DSPS. Just so we stay on the same page, I will often be referring to the Division of Legal Services and Compliance as DLSC for short. Now, as you can see from this flowchart graphic, we have 4 main stages to our complaint handling process. So the 4 stages include the intake stage, investigation stage, legal action stage, and the hearing stage. The more detailed graphic on the right-hand side of this slide includes further information regarding each of those 4 stages, and we will discuss those in more detail as we go. Now, discipline may be imposed following the investigation stage, legal action stage, or the hearing stage. So what does that look like? Complaints are resolved either in a non-disciplinary fashion or via agreed upon or imposed discipline. The 3 objectives that DLSC pursues when resolving complaints are 1, protection of the public, 2, deterrence of the conduct, and 3, rehabilitation of the credential holder. As noted on the slide, punishment is not an objective. So I will be using terms such as informal and formal closure, as well as disciplinary and non-disciplinary complaint resolution. And to avoid any confusion with these terms, I just want to explain them a little. So these are not equivalent terms. Informal versus formal closures identify whether a case was resolved prior to hearing, which would be informal, or after a hearing, which is considered a formal closure. A case that is resolved with discipline does not equate to formal closure. Discipline may be imposed via informal closure, and this is often accomplished via stipulation, where DLSC and the respondent agreed to acceptance of discipline, foregoing the need for a hearing. So while our discussion today focuses on disciplinary authority, I did want to point out some of the types of non-disciplinary resolutions that our division staff may pursue. So just for your edification, these would include closing a case due to a finding that no violation has occurred. This usually flows from an investigation that has found no evidence or maybe lacking evidence of a violation. Review of a complaint allegation may also result in a conclusion that the agency lacks jurisdiction. So we may see this in complaints asserting a fee dispute, for instance. This is more appropriately resolved through the civil court system, and in fact, the authority of our department does not extend to issues such as fee disputes between 2 parties. Cases can also be closed due to prosecutorial discretion, where the division attorney and case advisor conclude that the transgression was extremely minor and compliance has already been gained, or possibly the board has already addressed the conduct identified in the complaint. We see this in cases where an individual has committed the same error on multiple occasions, which has resulted in multiple complaints being filed. The board can address that behavior through one resolution. We can use that resolution then as a basis to close the other ones for prosecutorial discretion. Cases can also be closed via remedial education, where a credential holder is able to demonstrate that he or she has obtained additional education or will obtain additional education to address the conduct at issue. And finally, cases may be closed via an administrative warning. Now, an administrative warning is not an adjudication of guilt. The details involved in that administrative warning are not public record. However, the specific issuance of the administrative warning is a public record. So if we look at the other half of this slide, we look at disciplinary resolution of cases. So this ranges from forfeitures or citations to reprimands, limitations on licenses, suspension, and a revocation or voluntary surrender. These are all public record, and as our discussion today proceeds, we'll look further into board authority relating to the different disciplinary options. But one thing I wanted to point out now is that not all boards have authority to impose forfeitures or citations. That type of authority, if not authorized by statute or administrative code, is not something that a board can pursue when it comes to addressing disciplinary matters. So when a DLSC attorney, or you as a case advisor, or as a board member considering a proposed resolution to a case, are reviewing your available options, it's important for you to understand the board's authority. As you've heard from Renee and Sarah, statutory and administrative constructs, and to a lesser extent published case law, are going to define your board's authority in the area of discipline. As I just touched upon, within disciplinary actions, individual board members may have two primary big picture roles. Number one is the judicial role of the final decision maker, and number two is the consultant role of a case advisor. So in these roles, you'll need to be aware of the scope of authority that the board possesses and the options available to address non-compliant acts and omissions. Generally speaking, with regard to a board's authority, Wisconsin courts have repeatedly identified public safety as the purpose of licensing. They have based this conclusion upon a logical construct where the state has police power to protect public welfare and safeguard the health, life, and property of its citizens. Now, the state accomplishes this important protection responsibility in part via licensing regulatory statutes. These statutes are enacted to benefit and protect the public and are not for the benefit of the licensed person or the business. Wisconsin employs a two-faceted regulatory framework to address licensing. First, Wisconsin statutes create the professional boards that operate under the DSPS umbrella. The authority for the creation and operation of the boards is found at Wisconsin statutes chapters 15 and 440. The Wisconsin Administrative Code then adopts additional rules that are profession specific and further delineate a board's disciplinary authority. Some basic tenets of board authority include scope of regulation. Generally speaking, boards can only regulate within their specific professional domain. For example, a medical board isn't going to be regulating real estate practice. State oversight of a regulated profession may also involve application of federal regulations for that profession. For example, the federally created appraisal subcommittee imposes case resolution deadlines that are not specifically enacted by Wisconsin statute, but are adhered to by DSPS. So the next several slides are going to provide some comparison and contrasting examples of statutory board authority relating to discipline, and then we'll get into some administrative code compare and contrast examples as well. So first up, let's look at Wisconsin Statute Section 441.07. This is a nursing board statute which specifies the board's authority to pursue disciplinary proceedings and actions. Now, as you can see, the statute authorizes conducting investigations and hearings. Further authorizes revocation, limitation, suspension, or reprimand of a license. The board's authority to impose discipline is predicated upon a finding that the credential holder has committed one or more of 6 listed violations, misconduct, or unprofessional conduct. Similarly, the Wisconsin Real Estate Examining Board, authorized under Wisconsin Statute Section 452.14 to conduct investigations, hold hearings, and unlike the Nursing Board statute, it's allowed to also make findings. While the nursing statute does not specifically authorize making findings, it does allow the board to use any information obtained during investigation and disciplinary proceedings, and this could be construed as roughly equivalent to the real estate board's authority to make findings. Now, the real estate board's authority then specifically allows for disciplinary proceedings and gives the board the power to revoke, suspend, limit, or reprimand a license when a license holder has been found to have committed any of 17 listed transgressions. Conversely, nursing has listed only 6 transgressions that merit discipline. As you can see, the specifics of each profession will impact the respective board's Now, as we've noted, the Wisconsin Administrative Code will further define a board's disciplinary authority. Key areas that the code addresses for each profession often include profession-specific definitions, complaint handling and investigation guidelines, disciplinary hearing procedure, penalties for noncompliance, and license reinstatement considerations. For comparison purposes, I have included code provisions specific to pharmacy and to cosmetology. So the Pharmacy Examining Board chapter is quite detailed, but I wanted to give you an idea of the scope of reference that the code can provide. This specific code contains 19 separate chapters. I've listed the 12 most commonly referenced in disciplinary proceedings for your review here. Now, most notably, this professional code delineates standards of professional conduct for pharmacists at Chapter 10. As you can see, or maybe you can't, I realize that the type is very small, but there are 21 different indicators of unprofessional conduct listed at Chapter 10. This type of information is obviously vital to prosecuting attorneys and board case advisors as they pursue identification of code violations and propose discipline. Now, similarly, the Cosmetology Examining Board has a Wisconsin Administrative Code chapter that delineates specific practice standards. Compared to the 21 indicators of pharmaceutical unprofessional conduct, the Cosmetology Examining Board looks at 9 indicators. Now, the Cosmetology Examining Board, unlike the Pharmacy Examining Board, has an additional arrow in its quiver, and that additional power is the ability to issue citations. The code provides not only the authority for issuing citations, but also the form of that citation. As I noted previously, boards that do not have an express citation authority cannot address noncompliance in this matter. I had an interesting experience with the Cosmetology Board back when I was a DLSC prosecuting attorney, I believe it was around 2009. A license holder had reported a conviction involving her participation in a murder. As I recall, she didn't actually commit the murder, but she helped cover it up. So when this was referred to our division for investigation, I assumed as a young, naive attorney that this would be a simple license revocation. It seemed logical that the board would be able to revoke this credential holder's license based upon this felony conviction. An experienced investigator, however, quickly educated me, explaining that it would not be quite that easy. Neither the code nor Wisconsin statutes precluded a cosmetology license holder from maintaining her license despite having a felony conviction related to murder on her record. To put it bluntly, the board did not have the authority to revoke based solely upon a felony conviction that was not related to the credential holder's work as a barber. So the investigator explained to me anecdotally that the practice of barbering is considered to be a profession that someone can learn and practice while incarcerated and later profit from after their term of incarceration. So this is all to say that assumptions regarding board authority can be dangerous. So knowledge of the scope and limitation on each board's authority is required when pursuing discipline. So putting the case law pronouncements, the statutory authority, and the administrative code authority into a practical light, we return again to our flowchart. So to give you a more detailed, but not extremely detailed overview of our process, I'll just run through this briefly. A complaint is received by DLSC. Our intake staff will often request a response from the identified credential holder. These processes are identified by the red boxes on the chart. So with that response, the complaint will then be forwarded for screening by a DLSC attorney and a board-appointed screening liaison. Now, if the screening results in a determination that 1, there's a likelihood of a statutory or administrative code violation, and 2, that the board has the authority and jurisdiction to pursue this matter further, the complaint is open for investigation. The attorney assigned to this matter will direct the investigation and request that an investigator look into specific statutory or code violations. This process is identified by the blue boxes. The investigator will then compile the evidence and present that along with a case summary to the attorney and the case advisor for review. The assigned attorney and the case advisor will then discuss appropriate resolution based upon the investigation's conclusion. Informal resolution of the case, which may include discipline, will then be communicated to the license holder, and the case may be moved to the legal action stage, as indicated by the green boxes. If informal resolution is unsuccessful, then the matter proceeds to the hearing stage, as indicated by the purple boxes, and a complaint is filed. Following discovery, a hearing is held. All evidence is compiled by an administrative law judge, and the administrative law judge prepares a proposed decision for the board's consideration. Now, it's important to note that the decision by the administrative law judge is proposed. Ultimately, it is the board that issues the final decision. Now, when an administrative law judge submits a proposed decision, the prosecuting attorney and the respondent are provided with an opportunity to submit objections to that proposed decision. The board is then presented with the opportunity to review not only the proposed decision, but also the objections from each party. Now, it's important to remember that the board has the authority to alter or revise an administrative law judge's proposed decision. We call this process a variance. So variances may be proposed by a license holder, his or her attorney, the DLSC prosecuting attorney, or by the board itself. A variance may be appropriate where a judge has exceeded his or her authority, made an incorrect finding of fact, or has misapplied the facts to existing law. By way of example, the Medical Examining Board recently reviewed a matter involving a doctor who failed to report that he was under criminal investigation and was later convicted of a crime. DLSC and the case advisor reviewed this matter and looked at board historical imposition of discipline in similar situations and concluded that a reprimand was the appropriate discipline in this case. The respondent disagreed, and the case proceeded to hearing. After hearing, the administrative law judge determined that an administrative warning would be more appropriate and issued a proposed decision ordering such a warning. Reviewing that decision, the DLSC attorney noted that the ALJ had overstepped her bounds. Specifically, an administrative law judge does not have authority to impose non-disciplinary action, and therefore we needed to submit our objections, and at the same time we submitted a proposed variance to the decision. That's just a fancy way of saying we drafted our own version of the decision and included the discipline that we had requested from the beginning, which was a reprimand. The board ultimately adopted our variance and issued that decision. So I've included some language pulled from case law, just some quotes, so you can take a look at some of the published decisions that have addressed a board's ability to vary an ALJ's decision. Now, as this case law confirms, the board owes no deference to an ALJ's recommended findings of fact or sanctions, and does not have to demonstrate that the ALJ was wrong in order to amend a proposed decision. That being said, the board must explain its reason for disagreeing with the ALJ's proposal in the decision that the board issues. Now, despite the wide latitude afforded to boards regarding their authority to modify a proposed decision submitted by an administrative law judge, the authority is tempered by considerations of public interest, equity, and effectiveness. From a divisional perspective, a lot of thought and consideration goes into a decision on whether or not to request a variance. Of course, when issues like an ALJ exceeding our authority pretty much requires that we pursue a variance, simply disagreeing with an ALJ's decision does not. As attorneys, we never want to lose a case, but of course it does happen. For that reason, the proposed decision allows each party to submit objections, and then the board, when considering adoption of the ALJ's decision, can review any comments submitted. This helps to inform the board coming to a final decision and issuing that decision. All that being said, again, it is not our standard of practice to always object when we lose a case. We will be looking into whether or not concerns regarding impact to public safety are going to need to be further addressed. We also consider the whole issue of equity and fairness. We took this matter to hearing. Each party was allowed to present evidence, and a judge issued a decision based upon her review of that evidence. Again, sometimes we're not going to be able to demonstrate a particular code provision was violated, or we are not going to be able to demonstrate that the requested discipline is appropriate. So again, we're looking at a lot of different issues when trying to determine whether or not to pursue a variance. And again, another one of those is the effectiveness, is the ALJ's decision and the discipline that the ALJ has imposed. Is that the best way to address the alleged misconduct? And so again, it's just each individual decision is very unique and is individually analyzed, and through discussions between a DLSC attorney, that attorney's supervisor, my office, the Office of Chief Legal Counsel, we make a decision with regard to whether or not to submit objections and whether or not to pursue a variance. So I've just included some practice pointers, just kind of a recap of what we've looked at. So it's important as a board member that you review and familiarize yourself with the board's specific statutory and administrative code authority. If you have any problems finding that information specific to your board, you can of course contact me or anyone else in DLSC to direct you to that information. My contact information is included on the next slide, and don't hesitate to get in touch. Now, I've mentioned a couple of times through this presentation DLSC's review of a board's historical imposition of discipline. So again, when we're pursuing discipline, one of the things that we typically look at is going to be, what has the board done in similar situations in the past? It gives us an informed position with regard to how to approach the violation at issue. But one thing to remember is that a board's historical imposition of discipline is not considered to be binding precedent. An ALJ's decision is not considered to be binding precedent. So as such, there's no requirement that your current case has to be resolved in the same manner. So I just wanted to point that out. And then finally, it's It's also important to remember that each board and each profession is unique, both in practice and as it pertains to disciplinary options. There are many commonalities, of course, but understanding your board's specified disciplinary options is going to be essential to your participation in the compliance enforcement objectives of your board and for your profession. So that concludes my presentation on the topic of board authority and disciplinary matters. Thank you very much for your time today.
Thank you, Pete. Okay, we have a couple questions that will follow that presentation. One question that we got is regarding felony convictions. You did mention in your presentation about cosmetology specifically, but can you just discuss how each profession has a different analysis that needs to be conducted if when reviewing a conviction records on a disciplinary context?
So if I understand your question, then you're asking about how each profession is going to have its own requirements with regard to what we're looking at as far as discipline is concerned.
Yeah, I do know that some convictions, like private security guards, have a felony bar, but not all do. So much analysis is based on the actual crime that was convicted and how it relates to the profession, as Sarah discussed earlier. But from your perspective, can you discuss how how each profession is different and treats them all differently, and how
Right.
as board members they can work that problem out?
Right. And so yeah, like I said in my presentation, it really is specific to each profession. Some are more similar than others with regard to how they treat discipline related to a conviction. But unlike, maybe not necessarily unlike, but in contrast to what credentialing is looking at, when we're looking at disciplining someone, we also, like credentialing, do the substantially related test for most professions. So something like security guard, obviously, that felony conviction can be a bar, but in other professions it's not. And so our discipline that we're going to impose based upon a conviction is largely reliant upon the statutory authority or the administrative code authority that the boards are provided.
Thanks, Pete. We got another question from Dr. Schmaling of the Medical Examining Board. Complaints are very stressful for the complainant as the process feels less transparent, especially when the complaint lacks merit or it's ultimately dismissed. How are complainants notified of the progress of a complaint along the way? Especially when, for medical complaints where we're seeking multiple medical records, that process can be very long. So if you can give us some guideposts for which the complainant would be notified.
Sure. So complainants are notified upon receipt of a complaint, just to let them know that it was received. And then complaints are notified after our intake staff and the screening panel has determined whether or not to open a case for further investigation. Complainants may also be, communication may also be made to complainants in situations where the complainant is part of the investigation. For instance, in a medical situation, oftentimes our complainants are patients. And so they would be participating in or being part of that investigation. And then after that, a complainant would be notified of the resolution of the matter at the end of our process.
And similarly, though it wasn't asked, but respondents, if you're a respondent in a case or the complaint is against you, how are you notified through this process? Especially ones where we might not be seeking your information after that initial inquiry?
Yeah, so that's a little bit more of an involved question because respondents are oftentimes contacted to get a response, an initial response to a complaint that's been filed. But that's not always the case, however. There are circumstances where there may be ongoing criminal investigation that we are aware of. So we will make a determination that at this time we don't want to tip our hand or let the respondent know that an investigation may be occurring. And so in that case, the respondent may not be requested to provide a response. But it's more common than not that the respondent is asked to provide a response and then would be contacted as part of the investigation.
Thank you, Pete, for your presentation today. Today we have Lily Bem as the Assistant Attorney General in the Office of Open Government at the Wisconsin Department of Justice. The Office of Open Government team responds to public records requests on behalf of the DOJ. It advises state agency clients about the public records and open meetings laws and answers questions from the public about open government issues. Prior to joining the DOJ, Lily worked as an employment law at an employment-focused law firm in Madison. She has exclusively represented and advised employees of their civil rights and with respect to federal and state employment laws. Thank you for being here today, Lily.
It's my pleasure. My name is Lily Bame. I'm at the Office of Open Government, or the OOG as we call it, at DOJ. And today I'm just presenting on open meetings law, the essentials. So this isn't going to get into the nitty-gritty of every particular of the open meetings law, but certainly if anyone has questions, I will leave some time at the end so that if there's something I didn't address that you'd like to ask about, feel free. So the open meetings law in Wisconsin is grounded on this public policy. In recognition of the fact that a representative government of the American type is dependent upon an informed electorate, it is declared to be the policy of this state that the public is entitled to the fullest and most complete information regarding the affairs of government as is compatible with the conduct of governmental business. That's the public policy that underlies not only the open meetings law, but also the public records law. And it's what we at the OOG keep in mind when we're thinking through situations and whether they might violate the open meetings law or the public records law. The open meetings law is in line with that public policy, broadly interpreted to promote a policy of openness to the public. And you can find that at Wisconsin statute section 19.81 sub 4. Generally, the open meetings law is at 19.81 to 19.98, I believe. In line with that, when a situation presents a close question, so when something's kind of borderline, courts prefer an interpretation that favors open government or open meetings. Again, that's speaking generally. The facts of any situation would dictate how a court would find, but it is still in line with that same overarching public policy that in Wisconsin, we want to favor the rights of the public to be informed as much as possible what their government is doing. The purpose of the open meetings law is to ensure that openness. There are some limited exemptions permitting confidentiality or closed sessions, and we'll get into that. So when the open meetings law applies, it requires that all meetings of governmental bodies be preceded by public notice and are publicly held in a reasonably accessible place that is open to all members of the public. Again, when there is a closed session, that reasonably accessible and open requirement is not at issue, because then we have a closed session. But in general, public meetings have to have public notice, and they need to be held at a place that is accessible and open to the public. For example, like a country club, a private membership only country club, right, would not be a reasonably accessible and open place to hold a public meeting when the open meetings law applies. So again, open meetings law applies to a governmental body, but like everything in the law, governmental body has a legal definition. Here it means a state or local agency, board, commission, council, department, public body, corporate, and politic created by constitution, statute, ordinance, rule, or order. In plain English, a governmental body is any kind of collective governmental entity at a state, county, local, municipal level. A governmental body is created by some source of law, either a constitution, a statute, an ordinance, a rule, an order of the court. And a governmental body can be a governmental body even if it's called a board or a commission or a committee, an advisory board, things like that. So again, that includes purely advisory bodies, governmental corporations, something called quasi-governmental corporations, and subunits of all of those things. However, may be important for folks on this meeting to note that a governmental body generally would not include a group of administrative staff of a government agency. Again, that's fact specific, but for example, if I'm having like just a weekly team check-in with my colleagues at the OOG, those aren't open meetings because we are just staff of the OOG talking about our office business. But again, it's fact specific because we always have to come back to that overarching public policy that encourages openness. So moving a little further in, government bodies are created by constitution, statute, or ordinance, rule, or order. It refers to how the government body is created, not the kind of power that is vested in the government body. You can often simply look it up. You can Google it. You might get an AI result these days if you Google that you might want to check. But it should be pretty easy to see if an organization, a group, a body has been created by the Wisconsin Constitution, a statute, some other authority of law. An order that could create a body can include any directive that creates a body and assigns it some governmental responsibilities. That comes from a 1989 opinion of the Attorney General. That kind of directive that creates a governmental body can come from any official or entity. It can even come from another governmental body that has the power to delegate responsibilities. So a subcommittee of a county board, right, would still be a governmental body because it's been created by the county board, which is a governmental body. So again, fact specific, as in so many areas of law, it's hard to give a bright line rule. So when in doubt, look it up, contact a municipal attorney if that's available to you, another attorney you might work with. Or the OOG, we take questions from citizens all the time. So when is something a meeting? A meeting, again, it's funny to define this term, but because we're talking specifically about the open meetings law, we need to. So for the purposes of the open meetings law and today's presentation, a meeting is the convening of members of a governmental body for the purpose of exercising the responsibilities, authority, power, or duties delegated to or vested in that body. Important to note that this isn't limited to face-to-face gatherings or physical shared presence. For example, a conference call, a telephone call, sometimes even email chains virtual meetings like this and other electronic forms of communication, like Teams messaging or Slack, depending on what your workplace might use, those could all actually count as meetings for purposes of the open meetings law. How do we determine when some of those other things like email chains, conference calls, Teams chats, when might those count as meetings? The test that we apply is called the Showers test, and it comes from a 1987 case, State XREL Newspapers v. Showers. It's just a two-part test, so it's kind of broad, and again, none of this is a bright line rule. It really is fact specific. So in order for a meeting to occur, you need to have purpose. That is, members are convening for the purpose of conducting governmental business. Also need to have a numbers requirement. The number of members is sufficient to determine the body's course of action. A lot of people are familiar with the concept of quorums, of course. So certainly when you have a quorum of members present at a meeting, they could determine the body's course of action. But what sometimes folks don't think about as much is negative quorums, which is to say, if you have a negative quorum, that could still impact the course of action of the body, even if it just means that you might not be moving ahead and taking a specific action. You might not be able to agree to take a specific action. So the purpose part of the Showers test, again, the purpose for which a group of members is convening is to conduct governmental business. That's a really broad concept. It's not limited to really formal occasions or even final decision making. For example, conducting governmental business can include discussion, information gathering. There doesn't even have to be interaction among members of the body at the meeting. Sometimes also like preliminary decisions, temporary decisions. Again, it's broad, it's expansive, and that's in line with the idea that the public should have the most information possible about what its elected government is doing. The second part of the Showers test, that numbers requirement, again, it's not necessarily equal to a majority of the members of a governmental body, or even to a quorum of the body. All that you need is a sufficient number of members to determine a body's course of action. So of course, that could mean that you have enough people to give power to pass an action, to vote yes on a proposal, or the negative power to defeat an action, to prevent a proposal from moving forward. And that's, again, that negative quorum concept. Obviously, fact specific, depending on the governmental body, the amount of people who have to be there to make a quorum or a negative quorum varies between governmental bodies. A slightly more difficult concept here is the idea of a walking quorum, which is sometimes called a serial quorum. A walking quorum is when you have a meeting for purposes of the open meetings law that actually results from a series of gatherings among members of a governmental body. So what does that look like? You have a series of gatherings among groups of members. So say a group has 15 members. There might be, 4 members meet on occasion A, and 6 members meet on occasion B, and maybe 5 members meet on occasion C, right? So those are gatherings of groups of different members of the body. None of those meetings, A, B, or C, is sufficient in size to be a quorum. the key point is that the people at these meetings are agreeing to act uniformly. And there is a cumulative sufficient number of those members agreeing to act uniformly when they meet that they could control the action that the body takes. So the idea of a walking quorum is meant to prevent governmental bodies from circumventing the law through having agents or surrogates go around and obtain collective agreements of groups of members outside of a public meeting, so outside of the public view. As you might gather from this discussion, walking quorum issues are complex, and we definitely encourage people to consult with their legal counsel, or again, if you have questions, you can contact us and we'll do our best to help at the OOG. And contact information for that will be on the last slide. So recall that whenever there is a public meeting, an open meeting, notice is required. Every meeting of a governmental body shall be preceded by public notice. So it's shall, which is kind of a magic word for attorneys, right? That means it's mandatory. It's not an option. It's a command. So that notice must be communicated to the public and news media that have filed a written request for notice, if there are any, and the official newspaper for the community in question. If there isn't an official newspaper, then notice must be given to some news medium that is likely to give notice in the area. It'd be like a radio station, a public access television network. The presiding officer, of a governmental body is the person who is legally responsible. It's a typo, I apologize. Legally responsible for ensuring that notice requirements are met. The presiding officer may delegate tasks related to notice, but it is the presiding officer and not their delegee who will be liable for any violations. How do we give notice to the public? Remember that there's 3 kinds of notice that must be made, and the first is notice to the public. You have to pick one of these 3 methods on the screen to give notice to the public. You can post in at least 3 public places, or you can post in at least 1 public place and on the internet site of the governmental body, or you can pay to have the notice published in a news medium likely to give notice to the members of the public who would be affected by the meeting. You have to actually make sure that a notice is published if you pay to have it published. It's not enough to just send it to a paper and say, like, please put this in sometime. You have to follow through. Again, every meeting must be preceded by public notice. Specifically, it must be preceded by public notice at least 24 hours in advance of the meeting. And at least a full day before the meeting, the notice must be given to all 3 of those categories of interested individuals, the public, the news media, if any members of the news media have requested notice in writing, and the community's official newspaper. That meeting notice must inform the public of the time, date, location, and subject matter of the meeting. It's pretty common that a proposed agenda will be shared as meeting notice because the proposed agenda would indicate subject matter for the meeting in addition to providing the time, the date, the location of the meeting. So our notice needs to have subject matter, but how detailed does it have to be? All that the Wisconsin Supreme Court has said is that the description of the subject matter must be reasonable under the relevant circumstances. Relevant circumstances include the burden of providing more detail. So if I'm the presiding officer of a governmental body, how much more work, how much more trouble is it going to be for me to go into more detail? The degree of public interest in the subject. If the subject is not routine. So if I know, again, if I'm the presiding officer who's responsible and legally liable for giving notice, I have to think about whether this is a hot button issue, whether a lot of the public is interested, and whether it's something that doesn't come up a lot. If it's a subject that comes up a lot, maybe it needs a little less detail. If it's a novel subject, maybe more. Again, you need to apprise the public of what will be discussed. And in line with that, the notice should not simply use generic subject matter designations like old business, new business, miscellaneous, revisions to the agenda. That alone isn't good enough. If you use something like old or new business, you would have to get into what the old business is specifically that will be considered, or what the new business is. So you can use a generic heading, but you need to expand on that and give some details about what will be discussed under that heading. That's an issue that we see a lot in questions from the public, so we know it comes up. We'll get to closed sessions in a little bit, and the notice should include not only that there might be a closed session convened at the meeting, but also subject matter. So there are exemptions to the open meetings law that exclusively allow for closed session. So a meeting notice should include the statutory exemption that the body is relying on and the nature of what will be considered during the closed session. So leaving aside closed sessions for the moment, we'll go to open sessions. That's the general case for an open meeting. Again, all meetings shall be publicly held in places reasonably accessible to members of the public and shall be open to all citizens at all times, unless otherwise expressly provided by law. An open session of a meeting means a meeting which is held in a place reasonably accessible to the public and open to all citizens at all times. So obviously there's some overlap between the definition of an open session and what is required of an open meeting. Also, just call out the reasonable accessibility part. There is some component of that relies on thinking about accessibility for people with disabilities, say. So if you are in the position of planning where to hold an open meeting or an open session of a meeting, just keep that in mind, that things do need to be reasonably accessible to members of the public. That doesn't mean that it needs to be perfect, best case accessibility, but just keep in mind that members of the public might have all kinds of different abilities and ways to access things. Gets us into COVID's impact. Boy, the last couple of years have really changed how we think about meetings, right? I mean, we're doing this via Zoom. I'm sure a lot of us were on just innumerable Zoom meetings, Teams meetings, whatever, over the last few years, right? That we wouldn't have been in 2019 and before. So the type of access that is reasonable during the pandemic circumstances, thinking back now to maybe 2020 to 2022, where a lot of workplaces were more remote, would be different from what is reasonably required in other circumstances. So again, factual question, no hardline rule. That said, the Attorney General has advised that bodies may convene meetings via telephone or video conference. Courts have not said for certain whether convening meetings in this matter is always permissible. So keep that in mind. Again, no, unfortunately, not a hard and fast rule there. The main thing is that the public has to have an effective way to monitor these meetings. And so If you're going to have a meeting that is held via telephone or video conference, that notice must include details about how someone could attend remotely. So a call-in number, login information. People need to be able to get into the meeting and attend it, whether or not it's happening in a physical space. The bottom line is that the more access to meetings there is for the public, the better. Even now, as we've moved into post-pandemic life, most of us, it's best to provide multiple options to the public to attend those meetings. Fulfills the openness purpose that underlies not only the open meetings law, but also the public records law. So while citizens must have the right to attend and observe open session meetings, the law does not require a body to allow the public to speak or actively participate. Important. Public needs to be able to attend and observe open sessions, but the public is not required to have the opportunity to speak or actively participate. That is to say, the open meetings law doesn't require that. There may be some circumstances in certain municipal meetings that require public participation. That's not my expertise, that's outside of my scope. So again, contact legal counsel if you have questions, but the open meetings law doesn't require active citizen participation. It does permit a portion of an open meeting to be set aside for public comment. Again, public comment periods not required. If there is going to be a public comment period, it needs to be included on the meeting notice. During public comment, a body can receive information from the public, can discuss any subject brought up by the public, but formal action cannot be taken. Recording. A governmental body must make a reasonable effort to accommodate folks who want to record or photograph an open session, but that recording or photography may not disrupt the conduct of the meeting. Does not require governmental bodies to permit citizens to record or photograph closed sessions. And again, we'll get into closed sessions in a few slides. Voting. No secret ballots may be used except for election of officers of the body. So roll call votes can always be required. And all motions and roll call votes must be recorded and preserved. This gets into what kind of record keeping is required. A lot of times people will write into us at the OOC and express concern about the ways that meeting minutes are being kept. For example, in their townships or at their school boards. All that the open meetings law requires is that a record is made and preserved of all motions and roll call votes. There's no time frame by which that record needs to be created. Voting records must be open to public inspection. That gets into some overlap with the public records law. So again, the requirement to record and preserve motions and roll call votes is not a minute keeping requirement. Minutes, again, might be required by other statutes. That's outside the scope of this presentation. But because of that, and I think just because it's something that a lot of us are familiar with, minutes tend to be the most common way we've seen that people keep records of motions, roll call votes, and the conduct of meetings. Finally, closed sessions. Even if a meeting is going to go into closed session at some point, it has to start in open session. Then, at the appropriate time, a motion must be made and carried in open session to go into closed session. And that vote on whether to go into closed session needs to be recorded. Before that vote occurs, the presiding officer of the body needs to announce the statutory exemption, authorizing the coming closed session, and the nature of business to be considered in that coming closed session. closed sessions must be limited in scope. That means that only the specific business for which the closed session was authorized may be discussed. A governmental body needs to limit itself to that. It can't just segue into some other unrelated discussion while still in that closed session. A body has the discretion to allow anyone it wants to attend a closed session. Doesn't have to be, it's a closed session, and that's why there are exemptions, but there is discretion to allow other people to attend. That said, no elected or appointed member of a governmental body may be excluded from any meeting of the body, closed or open. And a member of the body also may not be excluded from a meeting of a subunit of the body. So if I'm on a county board, I need to be allowed to go to a subcommittee meeting, even if I'm not on that subcommittee, unless the county board has a rule that says otherwise. This is a complicated topic, closed session. So the Wisconsin Supreme Court back in the 60s had held that a body can vote in closed session if the vote is integral to the authorized subject of the closed session. However, more recently, still in the 80s, but more recently than the 60s, the Wisconsin Court of Appeals indicated that a body should vote in open session unless a closed vote is expressly authorized. That's a Court of Appeals case, and it didn't discuss that Supreme Court case from the 60s. So the case from the 60s is still controlling law. So yes, a body can vote in closed session as long as the vote is integral to the authorized subject of the closed session. However, DOJ does advise governmental bodies to vote in open session unless doing so would kind of defeat the purpose of having gone into a closed session in the first place. So again, keep in mind there's some disparity, there's some daylight between what the law actually allows, what that in line with that 1963 court case, and what DOJ advises. And our recommendation, again, stems from the openness purpose of the open meetings law. So just because you can doesn't mean it's always advisable, I guess is an easier way to say that. If you want to find out specifically what the authorized subjects are for which you can go into closed session, those are exemptions to the open meetings law. You can find those listed at WSStat chapter 19.85 sub 1. The next slide you'll see gets into some of the exemptions. Note that it's not a complete list. You can check out our office's open meetings law compliance guide at that link there for a more complete discussion of all of the different exemptions and when they apply. So again, here are a few of the exemptions. So subjects for which a closed session may be authorized. You can see them here on the screen. Deliberating about a case that has been the subject of a judicial or quasi-judicial trial or hearing before the body, considering dismissal, demotion, licensing, or discipline of a public employee, or charges against that employee, considering employment, promotion, compensation, or performance evaluation of a public employee, considering specific applications of probation, extended supervision, or parole. This in D here is obviously perhaps more relevant to folks who might be involved in the criminal justice system, for example. Deliberating or negotiating the purchase of public properties, the investing of public funds, or conducting limited public business whenever competitive or bargaining reasons require a closed session. So competitive or bargaining reasons, often we're talking about like collective labor, unions, but that exemption is broad enough that it does include generally spending public money, investing public money, or buying public properties. The next two, F and G, are, I think, more common sense, maybe. considering sensitive personal information that would be likely to have a substantial adverse impact upon an individual's reputation, and conferring with legal counsel about litigation strategy. Again, this is not exhaustive or a complete discussion, so check out that statute 19.85 sub 1 for the full list of exemptions. You can also check out OOG's compliance guide. How do we enforce the open meetings law? A couple of different ways. The open meetings law may be enforced by the Attorney General, a local district attorney at the county level, or by a private citizen. WSTAT 19.97 gives those options. If a governmental body is found to have violated any portion of the open meetings law, there can be a fine, a civil forfeiture of $25 to $300 per violation for any member who knowingly attends a meeting held in violation of the law or otherwise violates the law. So any member of the body can be subject to that fine, not just the presiding officer, as long as it can be proven that they knew that what they were doing violated the law, or they knew that the meeting they were attending violated the law. A member is not liable for attending an unlawful meeting if the member makes a motion or votes in favor of a motion to prevent the violation from occurring. So, again, it's really up to the individual members to know their stuff under the open meetings law, and stand up for it if they're in a situation where they feel like a violation might be occurring or about to occur. Similarly, members of a governmental body who in good faith rely on the advice of legal counsel of the body may not be found liable for any violation. Again, all of this is fact specific, clearly, but it is important to note that these are penalties for individual members of governmental bodies, and that your intent and your good faith in trying to follow the open meetings law can really make a difference in whether or not you get hit with a fine. If there is a public meeting that is found to have been unlawful because it violated the open meetings law in some way, actions taken at those meetings can be voided if the court finds that the public interest in the enforcement of the open meetings law outweighs the public interest in sustaining the validity of the action. So if the judge thinks that it's more important to enforce the open meetings law and promote the public's access to representative government than to uphold an action that was taken at an unlawful meeting, the court can void an action. I also said that individuals can enforce the open meetings law. Often you would file a verified complaint with the Attorney General, and if within a certain period of time, I'm sorry, not with the Attorney General, a district attorney. And if within a certain period of time, the county's district attorney doesn't act, then there is an opportunity for the individual to file a lawsuit. Sometimes folks will write into us at OOG and ask the Attorney General to take action. And of course, the Attorney General can, but as in public records law cases, the Attorney General usually exercises its authority to take action to enforce the statutes if an issue is novel or of statewide importance. So it is more common for a county district attorney or an individual to bring an enforcement action on their own. We do take fairly regular correspondence from individuals who have questions or concerns about how various governmental bodies with which they're affiliated or by which they are affected in their daily lives conduct their business. If we have questions or concerns at the OOG as we're reviewing this correspondence, we will often reach out to the governmental body, if that's a clerk or a board member, so that we can get more information about what's going on and see if the law was followed, see if maybe there's room for improvement, just try to clear up whatever we can and ensure that people understand what's required. So here you can see, last slide, this is our contact information. So that opengov@widoj.gov is our office's main email line. That comes in, and then I or one of my colleagues will review and process and respond to correspondence we receive there. We are located in the Capitol office, the Attorney General's Capitol office. We're not in RISR with the rest of DOJ. That said, we're behind security because we're close to the the governor's office. So we used to be more accessible to the public before 2019, 2020, but now we're not. So we don't, unfortunately, encourage drop-ins now because we can't bring you back if we're surprised, basically. So get in touch with us if you want to talk by that email address, the phone number there, or you could reach out to me directly. That's my phone and email right at the bottom. Or Paul Ferguson, who is my supervising assistant attorney general, and his phone number and email also appear there. All of this is available at our portion of DOJ's website. So this URL here, you can find our compliance guide there. You can find recent attorney general's opinions that relate to open government issues, copies of the statutes, recent responses to correspondence, open meetings advisories that we put out during the earlier phases of the COVID pandemic. Those can still be helpful as we all navigate how to have these virtual meetings and make them accessible to the public.
Thank you so much for that presentation from OOG. Now I'm going to get to say that. I'm really excited.
Yeah.
Really fun to say. Our first question comes from Bob Blakely. He serves on the Real Estate Curriculum and Examinations Council. His question is about the separation of powers doctrine. Do you have an example of a court ordering the creation of a government body, which is then subject to open meetings?
Yeah, most of the examples that we have are going to come from directives from other governmental bodies. Maybe a closer example would be a criminal justice study commission. So maybe the Wisconsin Department of Justice works with the law schools and the state bar to create a criminal justice study commission. That's a closer one, but yeah, I don't have an example. It would be the rare entity that were created by a court case. Obviously, just want to cover our bases. Hasn't happened, but it might. And we have to think broadly about what's a public body, what's a governmental body.
Okay, thank you. Our next question comes from Amy Kroll. She is on our hearing and speech examining board. Her question is, she has questions about interacting with fellow professionals in her job to determine if they can talk about the licensing exam or application process. For example, individual applicants often contact her to see if they can receive any aid in why their application is taking longer or any ways to interact with both the board and the department. She has had success in reaching out with the department, but she's wondering if there is an issue with this as being a board member. Should she have someone who is not a board member reach out to the department for assistance? Or is there other examples or other best practices she should take into consideration?
Boy, I guess I don't see an open meetings law issue with that. If anything, there might be a public records law issue. You'd have to consider whether any emails that you have, the email chain about that, other documents would be public records that would be subject to disclosure upon request under the public records law. Otherwise, I don't see an open meetings law issue with that necessarily. You know, it again going back to that showers test, right? You have to have the purpose to conduct government business, but you also have the numbers required to take action, and I think it's the numbers piece that's kind of missing there. So yeah, I don't see any open meetings law pointers, but just be on the lookout for when you might be creating a public record when you're having those correspondences.
And we always recommend for our board members on the call that you should reach out to your executive director as your first point of contact, and they can help figure out what the individual situation may be and who the best point of contact is. We know that you are professionals, and so you're out in the field, and so you may get unsolicited contact. By forwarding those to the department, we can then take it from there. But as Lily mentioned, you as board members are subject to open records, and so you should follow the best practices in things in maintaining those open records, as we've discussed a little bit earlier in this presentation, in previous presentations, and in our memo that we send around annually. Okay, so I'm going to move to the next question then, which is from Susan Kleppen from the Pharmacy Examining Board. She's talking about specifically in-person meetings and how the courts have maybe not resolved whether a meeting can be wholly in person and not available, say, online.
Yeah. Right. Okay. So I've got the question in front of me. That's yeah. Susan's picked up on a live topic here. I think there isn't hard guidance from a court case that I can point to here to say, like, yes, for sure, you can only meet in person or you can only meet virtually. Again, this just comes back to it's very context dependent, case by case, whether that's okay. Certainly, there's that reasonableness consideration. So different circumstances might make it reasonable to meet only in person or only virtually, but DOJ again advises as many ways for the public to access open meetings as possible. So if something is in person, maybe that means figuring out how to have like a call-in line for it, or figuring out how to put a camera in so that people can join remotely. Likewise, if something is remote only, is there a way that you can offer a physical space that people can come to watch it? Again, that's not always going to be required, but we do want to be as open and accessible to the public as we can be. So, you know, the more ways that you can provide for the public to access a meeting, the better. There's not really okay, there is access remotely, I'm seeing here. Yeah, then I don't see a problem.
It's a continuously evolving policy since, as we mentioned, the pandemic, where we went all virtual. Prior to that, we were mostly all in person. So it's been a evolving landscape, but in this last year, some boards have met more than twice a year. Some have met not at our offices, but at other locations as well. But generally speaking, it's our best practice to always have that it be a Zoom meeting so you can connect remotely, even if it is in person.
Yeah.
But if it is a virtual or teleconference, we don't generally get people in our office that want to attend in a room. But thank you for those questions. Lily, I had one question that comes up often. We have a lot of advisory councils that do not have decision-making authority, but meet, and we have them as an open meeting, but they are often concerned about the negative quorum, the walking quorum, because they have been asked to serve for their subject matter expertise. They interact a lot outside of our meetings. Is there any advice that you could give for those individuals on precautions that they should take or what they should be concerned about?
Well, I'm glad that they're concerned about it. That's good. I think people and groups tend to get into more trouble where they aren't aware of something that could become an issue. So that's all good. However, again, it's dangerous with it being so easy to communicate via email that we get into a situation where you have an exchange of emails that is really similar to an in-person meeting. You know, it can be nearly instantaneous and more like a conversation than discrete items of correspondence. So it's certainly possible that the equivalent of a quorum of this advisory committee or a subgroup might be receiving information on a real-time basis or an almost real-time basis through email, just like they would if they were meeting in person. So certainly that could be an inadvertent walking quorum violation, but it can still happen. So the Attorney General's office discourages members from using email to communicate about issues within their realm of authority. We know that that's not ideal in 2024, but it's really the safest way to proceed. You cannot decide matters by email voting, certainly even if a vote is later ratified at a public meeting that's been properly noticed. But the safest course is to still keep communication outside of email to the extent possible. And I would be remiss if I didn't bring up the public records issues that are raised by email communications too. Not to discourage anyone from putting things in writing, but whenever you do that, even if there isn't a risk of an open meetings issue, you are creating a public record. So not that that's a bad thing, but just, that needs to be retained.
And I would just add that this is about board business, that there could be communications you have with others that serve on a committee or council with you, that it's not board business. So if you're, or the governmental body's business. So if you're talking about, going to a restaurant, or if you're talking about like a specific patient contact that's not under the jurisdiction of the body that you're talking about, that wouldn't be considered a board business. And so there wouldn't be any open meetings considerations there. Especially if you're convened to discuss like a broad rule project. If you start moving into talking about that rule project or an issue you're seeing with the rule, then that's a problem.
Yeah.
But when you're engaging on something that's not considered your governmental body's business, then that sort of communication is okay.
Yeah, and that's more akin to the situation where maybe a group of folks on a board go out to dinner, but they're just out to dinner. It's not a dinner meeting. They're just, talking about personal stuff, sports, whose kids are getting married. I don't know, but it's not governmental business. So yeah, that's a good point. That's a crucial dividing line.
It looks like we have another question about how the legislature looks to coordinate the stance and create the laws on open and closed meetings in minutes, but if they have not discussed it without an open meeting.
Can you provide me more details or like a specific instance? God, I hate it. It's like the most lawyer right? Like it depends. But yeah, I don't know just from that question, like what's really happening here or how the legislature. Okay, I'm getting some answers here.
I think one of the interesting parts is that the legislature may not be subject to open meetings law. So as part of the executive branch, we're our governmental bodies are subject to open meetings law. So if you maybe want to expand upon that, but he did.
Yeah.
Stephen
Yeah.
from the Electrical Code Council had a follow-up comment too. You can see in the question and answer.
Right. So, yeah, again, just coming back to like the definition of a governmental body, right? It's a state or local agency, board, commission, council, department, or public body, corporate and politic, created by constitution, statute, ordinance, rule, or order. That's the full definition. I don't think that was in the slide because it's a lot. But you're right that the legislature is not always subject to open meetings laws, and that gets a little bit out of my scope just because there are other statutes that govern what the legislature does, how the legislature conducts its business, that I'm just not an expert in. So, I guess I should say, generally speaking, the open meetings law will apply to the state legislature, but it doesn't apply to like a caucus, a partisan caucus of a legislative body. It also doesn't apply if it conflicts with a rule of the legislative body. So generally, the open meetings law would be applicable and they would have to follow it, but there are numerous circumstances in which it wouldn't apply if we're talking about like a meeting of a partisan caucus of the state Senate or the state assembly, or if we're talking about part of the open meetings law that conflicts with a legislative rule. So, it really would be a case-by-case basis to determine whether or not any specific instance of the legislature acting in the way that the gentleman is describing, whether that would be violative or not. And I'm not familiar enough with rules of the legislature, Senate, or Assembly to be able to speak to every one of those instances where it would or would not violate the open meetings law.
But no, our committees can't have a caucus. I mean, that would be creating that negative quorum or some walking quorum on a particular topic of subject matter of the entity. Earlier in the presentations, back to when you heard my voice, I talked about how our power comes from the legislature. So it may seem like we're doing very similar things because we are creating rules, and so are they. But they grant us that power, and they mandate that we do that in an open setting. And so that's just a little bit more feedback that I would provide.
Yeah, because you're not the legislature yourselves, right? You're not the assembly or the Senate when you're meeting. So the exemptions that might apply to members of the assembly or the Senate don't apply to you all when you're meeting together.
So we have one more question. Lisa McNeil from the Massage Therapy Board. A walking quorum, how do we document or avoid this?
Well, I think I would probably need another hour to tell you all the different ways that you can avoid a walking quorum. One important thing to keep in mind is that there does have to be like an intent, to get around what the open meetings law requires. So a walking quorum is a series of gatherings among separate groups. Each of the group would be smaller in size than a quorum, who agree to act uniformly to reach a quorum. So it's like you have these different meetings, and at these meetings of small numbers of people, the attendees at that small meeting are agreeing that they will act in concert with each other to take an action. And then you would have enough agreement that you wouldn't need like an open meeting to put an issue on an agenda. I guess I'm trying to think how to explain it without making it sound like I'm like talking about a television show, a script or something. It sounds very like backroom and smoke and mirrors. And sometimes they are, right? But sometimes they're not. So I think just the easiest way to avoid creating a walking quorum situation is just to keep substantive discussion of issues to open meeting situations. So, you're not getting together groups that are coordinating amongst each other to act in a certain way at an upcoming meeting or without needing an upcoming meeting. Just, yeah, again, just keep things at the meeting. You don't want to circumvent the need to have things aired in front of the public. Again, there is that intent piece to it. A lot of times people aren't kind of sleepwalking into a walking quorum situation. That's not usually what happens. Yeah, I guess review the compliance guide. There's a little bit more information in there, but just best practices generally. When in doubt, you want to do things in public session or talk to the attorney who is, I don't know if that's Renee in this case or someone else, but who knows more like what your business is and what would be likely to come up at a meeting, and can say like whether or not what's being discussed in these smaller sections is governmental business that really should be handled in public.
And the best way to go about this is just to contact your executive director, and we can get those topics on our open open meetings, all of those noticed meetings. So I want to thank Lily again for presenting. You can see that our boards constantly have questions on open meetings and noticing, and there are all of their really worthwhile business. So thank you for coming today. And this will conclude our presentation for our board member training for 2024. So I hope you all found the content to be informative and useful in your roles as board members. Thank you for giving your morning to us. We will be sending a survey shortly, and that survey will give you the opportunity to give us some feedback so we can start planning our next training. And hopefully that training will look for that training for summer of 2025. If you have any content suggestions, you can send those to me directly, or you can include them in your survey responses. And thanks again to everyone for joining us and to all of our presenters today. So thank you all.